If you're thinking about buying a house, buying property, buying commercial property even, there's a case reported there in the Irish Times this week from the High Court. It's to do with a couple who ended up in what's called, or what's described by the judge as, a painful legal tangle over a parking space. And it's cost them a lot of money. And the judge seems to be suggesting that they need to revisit their options. Well, they certainly do. They had failed to properly investigate, or their solicitor had failed to properly investigate the planning non-conformity of the property that they had bought, and did not check the planning permission, the judge said. The house in Rathgar cost, or the property that they bought in Rathgar, Bushy Park, Rathgar, cost 1.64 million. The owners of this property, though, the people who bought this and brought this judicial review or this High Court action, they stood majestically aloof from a planning process that declared as unauthorised one of the 2 car parking spaces provided as part of their 1.64 million purchase. So they bought a property, 1.64 million, with what they believed was 2 car parking spaces in Bushy Park in Rathgar. Car parking space in Rathgar would be valuable, but the judge says that the couple, 3 years after the purchase of the property on Bushy Park Road, ended up in a painful legal tangle over a parking space. He said that he had sympathy for them, but it did not relieve them from choosing the correct legal route to resolve the problem, he said, when dismissing their case. And he obviously took the view that they chose the wrong legal route. He said that they had failed, amongst other things, to properly investigate the planning non-conformity of the property they purchased, and did not engage a surveyor or otherwise check the planning permission as against what had been completed on the ground. So this is a message, this is a lesson for anyone buying property. Get a survey done, but also make sure your solicitor has a good close look at the planning situation. They brought judicial review proceedings against Dublin City Council, seeking an order quashing a decision requiring that permission for the 8-unit development, which their house is part of, meant their second car space did not have planning permission. So they brought a judicial review, but the judge and the Dublin City Council said that that was the incorrect course of action to take. There was only permission granted for 12 spaces for the development built on a former site at 59 Bushy Park Road, which built 13 spaces. So there was only permission for 12. The developer then submitted a retention application for the 13th space to the City Council. This was refused, however. It was the space that was bought by this couple which was affected by that decision. They then sought to appeal that decision to An Bord Pleanála, but the board ruled it could not deal with such an appeal because the council's decision did not differ materially from the original permission granted for the development. They did not challenge the board's decision, An Bord Pleanála's decision, but they brought a High Court proceeding seeking to challenge the City Council's decision. They claimed that the decision was irrational and was invalid because the developer did not have their consent when he applied for retention, as it affected land owned by them. The City Council opposed the action, claiming, amongst other things, that they had failed to exhaust the available appeal procedures and/or other administrative remedies which were available to them before coming to court. And ordinarily, if you don't exhaust the administrative remedies open to you, then the High Court is not the place for a judicial review, because a judicial review will not succeed. Dismissing the case, the judge said that their failure to participate in the process had been compounded by the further failure to challenge the board's refusal of leave to appeal. The council was correct in saying that there were at least 4 other remedies available to them, he said. Insofar as they said they had not participated in the process, including in the developer's application for retention because their consent had not been sought, that is, the dog ate my homework excuse, the judge said. The failure to exercise the available administrative remedies was disqualifying for relief by way of judicial review, he said. That's important to understand. You can't just trot off to the High Court and seek a judicial review if there are administrative remedies open to you. The judge said that normally during the conveyancing process, and this is vital, any non-conformity with a planning permission for the property is addressed, generally by way of a survey. In this case, he said the developer provided a certificate of compliance with the planning permission, but that did not seem to have been meaningfully challenged or investigated on behalf of the applicants. Why the development was certified as being compliant is one of the unanswered questions in this case, he said, and I would have some sympathy for the couple in this case if they were relying on a certificate of compliance from the developer or developer solicitor or developer, and it turned out not to be the case. One might also wonder why the developer and their solicitors didn't notice that they were drafting documents for the sale of 13 spaces when only 12 were allowed, he said. So again, I have some sympathy for the couple in that regard, because they relied on the cert. Their solicitor presumably relied on the cert that was furnished to him or her as part of the conveyancing process, and that would be the normal situation. If Miss Hughes and Mr. Sinclair, as the couple, hadn't become too embedded in their existing doomed strategy, one can only encourage them to have a fresh look at their options, he said. The options could include making a fresh retention application, perhaps coordinated with the developer, he said. The others are complying with the permission and taking the loss and selling up. So that is an expensive outing in the High Court. Their case was dismissed. That of itself is an expensive venture, and then they have the added problem of having bought this property thinking that they were getting 2 car parking spaces when in fact there's only planning permission for 1, and now they only have the 1 car parking space. They paid 1.64 million for the property. It's in Bushy Park in Rathgar, so you can't be too careful when it comes to planning and buying properties and so on. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. You may also be interested, if you're watching this on YouTube, watching this video up here. Thank you very much.